afternoon. My name is Oliver Westmoreland. I'm Senior Immigration Lawyer at GSM Immigration. Please subscribe to our YouTube channel and click on the bell icon so you can continue to watch our extremely interesting videos about UK visa and immigration advice. Today, I'm going to talk about unmarried partner visas, particularly applications made within the UK. I better tell you first of all what the legal definition of an unmarried partner is as far as the Home Office is concerned. It's two people, same sex or different sex, who have lived together in a relationship akin to marriage or civil partnership for at least 2 years. That's the legal definition. You may find other definitions elsewhere, but that's the definition that the Home Office uses. A visa, unmarried partner visa, is very similar to other types of partner visa. It's very similar to a spouse visa or a civil partner visa. It's got lots of the same rules. There are rules about money, rules about required earnings. There are rules about accommodation. There are rules about English language. And of course, there are rules about genuine and subsisting relationships. Subsisting is a word that the Home Office like. I think it means ongoing. So genuine and subsisting relationship is a relationship that's true and real and genuine, ongoing today. That's what it is. All these other various rules are exactly the same. I'm not going to go through them today because probably you're familiar with these sort of rules anyway. In this case, as it's an in-country application, either one or both people can show that they're earning at least £18,600 gross per annum. If there are children involved, the sum's a bit higher. This is the basic scheme for one person applying, one migrant applying. Earnings of at least £18,600 gross. Adequate, decent accommodation, doesn't have to be large or grand, but it has to be adequate. English language. Many migrants who are in the UK already, I think they probably would have passed an English language test anyway, or they might qualify anyway for the English language. So the English language is part of it, same as with the other routes. The thing that's different about unmarried partner visa application is this 2-year cohabitation requirement. Other partner visas, there is no such requirement. If you want to apply for a spouse visa, according to some people, it'd be quite wrong to show that you've lived for 2 years with your partner. This sort of requirement does not exist for spouse visa or civil partner visa, but for unmarried partner visa, this is the basis of the application, that you've lived together for 2 years in a relationship. Now, you've got to prove two things, well, pretty much anyway. First of all, you've got to prove that you have lived with your sponsor, who may be a British citizen or settled or so on. You've been living with your sponsor for at least 2 years. You've got to produce good evidence about that. You know the kind of thing, bank statements, utility bills, doctor's letters, anything from local authority, anything that has an official sort of look about it like that. But you need a fair quantity of evidence. B, this evidence has to be spread over the 2 years. It's no use if it's only at the beginning or only at the end or only in the middle. It's got to be reasonably well spread through this 2 years. You've got to prove that. A second thing you've got to prove, a bit more difficult, you've got to prove you're in a relationship. How do you prove that? Well, like with the normal way, you have your WhatsApp messages, maybe emails, birthday cards, Christmas cards, all that kind of thing. I think if you can prove that you've lived together for 2 years, that is the main thing. This other evidence, it's common and standard. It's not so difficult, is it? The difficult thing, probably in most cases, or the more difficult thing, is to provide sufficient good evidence to show the 2-year cohabitation. If the Home Office is not convinced, I think most typically the refusal is not based on whether the relationship is genuine. It could happen, but Probably more typically, the Home Office is not convinced that you've provided sufficient evidence that you've been living together for 2 years. If that should happen, sometimes it does because maybe people 2 years ago didn't realise that they were going to have to collate this evidence together. You have to make an effort. Maybe people didn't realise that this was important. Sometimes people don't have enough evidence. Sometimes the Home Office will ruthlessly refuse. In a way, I suppose you can't blame them. A marriage is easy to prove, isn't it? You can have a marriage certificate, you can have evidence about a big wedding ceremony and so on and so on. And married partner, there's nothing quite like that. There's nothing similar. Home Office is quite ruthless. If they say that you haven't provided enough evidence for the whole of the 2-year period, Home Office may refuse the application. If that happens, you could either try again, fresh application, possibly. If you think that's not going to work because you don't have much new evidence, much more evidence, you might want to go to appeal. There will be right of appeal to the first immigration tribunal. If it comes to it, you may have a better chance at appeal. First of all, because some time will have gone by. Now, this kind of appeal would be deemed to be a human rights appeal. In a human rights appeal, the judge at the tribunal can take into account evidence coming right up to the day of the appeal hearing. So you will have had more time to collate more evidence. The 2-year period, effectively, it's moved forward a bit. Secondly, judge can take evidence from witnesses, so on. Judge can assess the demeanour of the migrant and of their sponsor, most probably, and he can decide whether he thinks the relationship is genuine or not. If the application fails and you've done your best, you've got an appeal. You've got a good chance to rectify the situation if you follow your excellent lawyer's advice. Hopefully, it doesn't come to appeal. Hopefully, the application is successful. You get granted leave in the same way as other partners. 2.5 years leave could be extended, hopefully, to another 2.5 years leave. After 5 years, you might qualify for settlement if you meet all the requirements. If you don't meet all the requirements, you might have to go on the 10-year route to settlement. If, for example, you don't meet the financial requirements, but nonetheless your application is successful, you may go on the 10-year route to settlement. Other thing, although the normal standard rule is that the migrant has leave when they apply, it's a general rule in immigration. You're supposed to have leave in something to apply for leave in something else. And sometimes this rule is very strict. In this case, the rule is not quite so strict. An overstayer, somebody who has overstayed their visa, might be able to make an application. Well, will be able to make an application. Whether it's strong or not rather depends. Could be difficult. I would say, from my experience, if there are children involved, it's going to be stronger. If there are not children involved, it might be weaker. If your lawyer advises you that it's a weak application, maybe better not to bother. Maybe better, if you can, go back to your home country and apply from there, because then you haven't got the same requirements to meet, and having been an overstayer will not be held against you. Now, that's the basic scheme that Mr. Shaw, I can see from your eyes that you've got a lot of, you're brimming over the questions for me.
Yes, thank you so much, Oliver, for such a detailed vlog about unmarried partner visa for someone to be able to switch within the UK. We do have some questions that we get asked frequently, and I would like to put these forward to you. I'm in the UK as a visitor. Can I switch to unmarried partner visa?
That's a very good question, and for once I have a clear answer. Unfortunately not. Visitors, unless there's some very strange bad human rights situation in their home country, visitor cannot switch to partner visa of any sort, and indeed anyone who holds a visa of 6 months or less cannot switch.
Okay, and can a couple combine their income if they're unable to meet the financial requirement through just one person's income?
Yes, they can. As long as the migrant is working lawfully, which hopefully in most cases they are, they can combine income. If they still don't have enough income, they could both combine savings.
Okay, and somebody who works with the NHS in the care sector as a nurse, for example, If she was to switch to the unmarried partner visa, would she also have to pay the immigration health surcharge?
I think she would, because she's applying not as a healthcare worker but as something different. Sorry, guys.
Thank you. And another question that we come across often is, I do not have much evidence of living together with my partner. Can I provide a lot of supporting letters instead to make up for it, to show that we've lived together?
Supporting letters from whom?
From friends and family.
Well, yes, of course, you can provide any evidence you like, but let me be straight with you. Such evidence is not as good. If you have more, it's probably better than less, but such evidence is not as good because, let's say, something from a bank. In most cases, it's genuine, isn't it? It's not impossible to forge letters from banks, so I've heard, but it's more difficult. It's more difficult to forge letters from hospitals. It's more difficult to forge official evidence. It's possible, but more difficult. Letters from people, not so much good by themselves. However, if you persuade them, if the application should be refused and it goes to appeal, then there could be witnesses, then it gets a bit stronger. But to be brutally honest with you, letters from supporters are not anywhere near as strong as letters from official sources that show the cohabitation.
Okay, thank you so much for clarifying that. And another question is, if a couple has lived together for about a year and a half, they haven't completed their 2 years of residence together at the moment, is there any exception to this requirement of living together for 2 years under this category?
I would say no.
Mm-hmm.
I mean, the Home Office has got power to make any generous decision that it wants, but in most cases it doesn't. It's not going to break that rule because that's the fundamental rule, the fundamental part of the scheme.
Sure. Okay. And if the person who's switching the visa is in the UK with a dependent child, can that dependent child also apply at the same time as the main applicant into this family visa category?
Yes, the financial requirement would be higher, but they can. But let me just say one thing. Almost any visa category can switch into partner visa or unmarried partner. There are a few exceptions, such as I mentioned, but almost every visa category can switch.
Okay. And the last question would be about the processing time. So this visa, usually how long does it take for the Home Office to process them?
Well, look, the Home Office publishes processing times. They say that it takes about 8 weeks. Some of these applications, I think they're going to take a bit longer because sometimes the evidence is quite complex and voluminous. Let's say, put it safely, 8 weeks or maybe a bit more.
Okay, perfect.
But like always, if the applicant's visa has expired before the decision is made, they don't need to worry. They do not become an overstayer. The law protects their immigration status. They do not become an overstayer. Even if it takes the Home Office 2 years to process the application, they do not become an overstayer for the whole of that period. So they can't be removed from the UK during that period.
Brilliant. Thank you so much for such a great vlog today, Oliver.
My pleasure.
We see you in the next one.
See you next time. Bye, everybody.